Your patent sucks because your provisional application doesn't support your patent's claims. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. One of the most misunderstood animals in the patent kingdom, in my experience, is the provisional patent application. Let me assure you, first of all, that there is no such thing as a provisional patent, although you will hear that term used frequently. A provisional patent application never, ever becomes a patent in and of itself. It basically sits in the patent office for a year, and then at the end of that year, you have to file a full-blown non-provisional patent application if you ever want to get a patent. The provisional patent application is, some people call it a placeholder. I guess that's fair. The purpose of it generally is to get an early filing date without filing a full-blown patent application. So why do you want the early filing date? Because when a patent is evaluated by an examiner, it's compared against a universe of pre-existing information that's called prior art. And the question of whether art is prior depends on what the filing date of the patent you have is, or the application that led to the patent. If you had a provisional application, and if the provisional application supports the claims, and I'll describe what that means your filing date is not the day you filed the non-provisional patent application, it's the year earlier when you filed the provisional patent application. There is a widely held misbelief that you can file a thin, cheap provisional patent application and still get an entitlement to a filing date that's going to hold up in litigation. And let me disabuse you of that notion right now. A provisional patent application is only good, its only utility is if ultimately that filing date holds up. And what that means is that the claims you have in your non-provisional patent, that the issued patent, have to be fully supported by the provisional. And by that I mean the things that are in the claims have to be derivable from the subject matter of the provisional. So if you added a bunch of stuff between the provisional and the non-provisional, in other words, if the non-provisional has a bunch of stuff in it that the provisional doesn't have, and if the claims of your patent rely on that stuff that was new in your non-provisional, then those claims are not going to be held to be entitled to the filing date of the provisional, and that provisional will have added zero value. It'll be like you never filed it in the first place. Now here's the rub. You're not going to know there's a problem with your provisional patent application for years, because how does this come up? This rarely comes up in the patent office, in my experience, because the patent examiners seem to try to find prior art that predates your provisional, so they don't have to worry about evaluating the quality of the provisional and its thoroughness relative to the non-provisional claims you're trying to patent. So it's in litigation that this comes up. And so what happens is you get into a lawsuit and a piece of prior art surfaces, and that piece of prior art has a prior art effective date, typically a publication date, or sometimes the filing date if it's under patent application, but it has an effective date that falls between the day you filed the provisional and the day you filed the non-provisional, which means if the provisional holds up, then your patent's filing date is effectively before that reference, and so it's no longer prior art. If your provisional filing date doesn't hold up, now your filing date of your patent is your non-provisional filing date, and now that intervening piece of prior art is truly prior, and now it can be used to invalidate your claims. So this will come up years and years, maybe 5-10 years easily, after you file the provisional patent application. That's when you'll see if it was worth it or if it was any good. Now, there are definitely benefits of a provisional from a cost-saving perspective, in the sense that you don't have to file claims and you don't have to file formal drawings. So yes, it is cheaper in that sense, but it's not cheaper in the sense that you can't just cut corners and leave stuff out without potentially hurting yourself on the back end. So personally, I don't like them a lot. I tend to use provisionals when the client basically screwed up and their backup is up against the wall. Like, for example, if they said, oh my God, we have a trade show on Tuesday and we haven't filed anything on this. Can you file something? And then I'll put together whatever I can. Because the thing with a provisional is you can file almost anything. It doesn't have to look formally correct like a patent or anything. You can file brochures and lab tests and white papers and all sorts of stuff, right? It's harder to use it to defend your issued patent claims if it looks less like a patent possibly, but still you can do that. And sometimes you'll hear the phrase cover sheet provisional, which means the client has prepared like a 1 or 2 page description of the invention idea. You'll slap a USPTO cover sheet on it or with it, and then you'll file it without doing anything to it. And the cover sheet provisional is something that you'll see done when there's truly an emergency because somebody screwed up or something happened that necessitates a disclosure of the invention before a patent application that can be filed. But the thing is, if you're going to disclose the invention like at a trade show, that's a real problem, because now if the provisional has less detail than the thing you're like if the product is fully developed and you're showing it at a trade show and the provisional doesn't describe all the stuff that's in the thing you're showing, that's a situation where you're very likely to file a non-provisional that won't be entitled to that provisional's filing date, because you know it's in the actual product and now all that stuff has been disclosed, but your provisional wasn't before it. So, I'm not a huge fan. Now, some companies I've worked with have a filing strategy. They like their first application to be a provisional no matter what. So I had one company, Fortune 500 chemical company, and their initial filing in every single case was a provisional patent application. However, it was a fully blown, I'm talking 40-page patent application. And when we went to the non-provisional stage, I almost never made any changes to it whatsoever. So that was just their filing strategy, because you do get that year where it's in the provisional stage where it's secret. So in theory, what could happen, and this is another benefit, you can file a provisional and stay secret for a year, and then you can decide I don't want to go forward with it, and you don't file a non-provisional, and the provisional dies, it never becomes public, so it never becomes disclosed. So that's something you can do. But yeah, I think provisionals are touted as being far more powerful than they are, as if, there's like some magic to them where you can get more out of them than you put into them. And that's just a false notion. Okay. So that's provisionals. I hope that helps to keep you out of trouble, and I hope to see you here soon.